Hey guys, thanks for watching Personal Injury Perspective. Today we're going to talk about the narco-terrorist attacks in the Caribbean. Take a look at these explosions, one after the other, broadcast on national television. 21 strikes in all. Boom. Right there. Another one. Boom. Boom. Look at these explosions in the open seas. People are dying, and we're told these are narco-terrorists that are being killed. But here's the question. How do we actually know? When a missile is acting as a judge, jury, and executioner, what protects the innocent? Is this legal? Is it constitutional? And what happens if one of the people blown up wasn't a cartel member at all, but an innocent fisherman, or maybe even a U.S. citizen? Let's talk about it. So, according to the U.S. government, these strikes are not random. Pete Hegseth, the United States Secretary of War, has stated publicly that the military has credible information on targets. He says these vessels are traveling along known narco-trafficking routes, carrying illicit narcotics, and in some cases operated by terrorist organizations, like the Venezuelan gang Tren de Agua. And let's face it, we do have a drug problem here in the United States. 83,391 died due to drug overdoses last year in 2024, and it was in 2023 it was 110,000. So there is cause by the Trump administration to take action, and that's precisely where the controversy lies on this one. The U.S. claims it is vetting these boats using drones, unmanned surface vessels, naval aircraft, satellite intelligence, and classified surveillance systems. In their words, they say, we know who these people are, we know what these boats are doing, and we have the intelligence and the authority to do what we're doing. And here in the U.S., these bombings have sparked a lot of controversy and discussion. This is mostly because Venezuela tells a different story. Regional reports say that not everyone killed on these boats were cartel members. Some were described as civilians, even fishermen, struggling to make a living. One AP report noted that a man earning about $100 a month was killed on one of these vessels. He was a fisherman. Some families say that identities are not confirmed, bodies are not accounted for, and some boats may even have been civilian vessels, not narco-terror shipment vessels. So their claim is very simple. Some of these people were not terrorists, they're just fishermen. Then we have the global reaction. A group of independent United Nations experts said these U.S. strikes in international waters may amount to extrajudicial executions, and they violate international law. Colombia's president has condemned several of the strikes, saying the U.S. is killing civilians whose identities were never verified. Some people in the worldwide political stage are asking what rules govern U.S. missile strikes in international waters, and what happens when the intelligence is wrong. So let's dive into the law on this. So we'll start with the innocent fisherman, a non-U.S. citizen mistakenly blown up by a U.S. missile in international waters. Can his family sue the United States for wrongful death? The short answer to this is no, and it's not even close, guys. We've covered the FTCA before in the past on some of my other videos. That's the Federal Tort Claims Act. The FTCA is the only mechanism to sue the U.S. for negligence, but there's 3 exceptions that immediately block the fisherman's family. First, there's the foreign country exception. It's 28 U.S.C. 2680K, and it says that if an injury occurs outside the U.S., the claim is barred. International waters equals foreign country for FTCA purposes, therefore no claim. Next, we have the combatant activities exception. 28 U.S.C. section 2680J. If the death occurs during a military operation, the U.S. is immune from liability. A drone strike targeting alleged narco-terrorists is a military operation. Even though Trump has not declared war on the narco-terrorists as he contemplated doing, this is still a military operation. In summary, the FTCA does not grant foreign nationals abroad any claim here. So the fisherman's family has no claim under the FTCA. There's also no constitutional claim. No constitutional rights attached to foreign nationals who are harmed abroad by U.S. military operations. Courts refuse to scrutinize targeting decisions. They call these political questions. The U.S. courts do not permit judges or the law to question targeting decisions, which would open the door to civil liability where those decisions were made even negligently or even recklessly. There's just no remedy under international law either. Under the ICJA, the International Court of Justice, or The Hague, it does not permit individuals to sue. Only countries can sue. And the U.S. doesn't accept compulsory jurisdiction. Then there's the International Criminal Court, or the ICC. This is a court that the U.S. is not even a member of, and we don't participate in it. But beyond that, the ICC does not hear civil claims, and this would be a civil claim. Finally, what about the UN or the United Nations bodies? Can they get involved? Sure, they can get involved. They can criticize, but they can't order payments or force any kind of justice here. So the bottom line for the innocent fisherman's family is that there is no justice. As such, for the first time in the history of this channel, I put this as a 0 on the personal injury perspective justice scale. I always like to be optimistic though. After all, I typically represent a plaintiff's personal injury, or the underdog in these cases, so the only light in the darkness is what they call ex gratia payments. These occur when the United States feels bad, or they feel like a wrongful act occurred and they want to voluntarily pay the family for the loss. In Iraq and Afghanistan, the U.S. military frequently used these payments to appease locals where there were friendly fire incidents. We've seen this in the movies. I don't know if you remember the documentary Restrepo. In that documentary, the U.S. military killed Afghan farmers' goats, so the soldiers offered ex gratia payments as compensation. It was like $100 per goat. You see that scene right here. However, that is not compulsory. It's 100% done with no acceptance of fault or need for payment. During those wars, it was done to win political advantage or keep the peace. Here, I do not see the Trump administration ever making an ex gratia payment to a Venezuelan person. So now, let's take it to the next level. What if the person blown up in international waters were a U.S. citizen? That hasn't happened yet, according to anything that I've seen, but does citizenship change anything? Shockingly, almost certainly no. First, we look at the FTCA. Citizenship does not override FTCA jurisdiction, and the foreign country exception that we talked about before, it still applies. If you're outside the U.S., the claims are barred. Also, the combatant activities exception, we talked about that earlier. It still applies. Military strike equals claims barred. So even if a U.S. citizen is on the wrong boat at the wrong time and is summarily executed by an AGM-65 Maverick J or K missile, that U.S. citizen has no personal injury claim. Finally, what about the U.S. Constitution? People have asked me, Chad, isn't this a violation of due process? I mean, people have asked me, how can this happen? The AGM or K missile can't just be the judge, the jury, and executioner, can it? Yes, it can. People assume the U.S. Constitution protects citizens abroad, but courts have made it very clear drone strikes, targeting decisions, overseas military operations, national security actions, they're just not judicially reviewable. Think about this in the context of friendly fire incidents during wartime operations. Typically, they are not actionable, even if it is a U.S. citizen. I look at the case of the United States versus Johnson, 1987. In that case, there was a Coast Guard pilot. He died in a rescue operation. His family sued the FAA. The United States Supreme Court came back and barred the claim under the military immunity doctrines that sat before it. Then we have the Ferris versus United States famous case in 1950. This was a foundational case. Under this case, service members can't sue for injuries incident to service. Courts interpret this very broadly in the military context. In summary, for a U.S. citizen driving his pleasure boat leisurely in international waters outside of Venezuela, and then boom, he dies. No FTCA claim, no Bivens claim, no due process claim, no Hague claim, no ICC claim, and no statutory remedy, unfortunately, folks. This is yet another 0 on the justice scale. The law simply does not provide a lawsuit even for an innocent U.S. citizen killed by mistake or friendly fire. So here's where we end up. When a missile becomes judge, jury, and executioner, when intelligence isn't perfect, and when the ocean effectively becomes a battlefield, our legal system does not offer justice, not for an innocent fisherman, and not even for a U.S. citizen. This isn't about politics. It's about reality. If I were a U.S. merchant, a U.S. fisherman, or honestly, anyone operating a vessel anywhere near Venezuelan waters right now, I would operate with extreme caution or avoid these areas altogether, because out there mistakes happen fast. Accountability comes slow. And unless you have some extremely good life insurance, the law will not be able to protect you. This has been Personal Injury Perspective. If you found this breakdown helpful, follow along as we continue to look at whether victims in high-profile cases like this one can truly obtain justice. Be safe out there, and don't forget to like, subscribe, and comment. I will see you on the next episode of Personal Injury Perspective.